The most unprofessional person I've ever seen sit on the Board of Education or any board. Don't interrupt me right now. Now I'm telling you, I'm telling you that right now. What are you going to do?
Wait. Just sit down.
You want to threaten me?
Look.
You want to threaten me?
I'm not threatening you.
What?
Good evening, ladies and gentlemen. Welcome back to the Squatch Watches Meetings channel. Tonight's meeting comes courtesy from North Carolina, where the Johnston County Board of Education is holding a special session on September 25th, 2023. This special session was called because of a grievance filed by someone against one of the school board members, Miss Michelle Antoine. The presentation from the board's legal counsel fuels some rather heated discussion. This meeting has everything: a challenge to a fight, yelling, interruptions. Before we begin, remember, these are elected officials, and allegedly, they are adults. Just remember that. Right. Crack open a Cheerwine, and let's get into the video.
Ms. Coronado, I will turn it over to you.
Good morning, board members. I'm here today to address a redacted investigative report you received yesterday. And it may only be considered by the board in open session pursuant to General Statute 143-318-11A6, which states a public body may not consider the qualifications, competence, performance, character, fitness, appointment, or removal of a board member of the public body except in an open meeting. The discussion today is going to keep confidential employees' names, and they're referred to throughout the report as Grievance and Employee 1. And in addition, there are witnesses identified as Witness 1 and 2. It's possible that after today's discussion, additional information would be presented to the board. My recommendation to the board is to consider and discuss this report and then vote to receive the report. I'll turn it over to Ms. Williams, who was an investigator, and if you all have questions, this is the time to direct them to her.
I'm open to receiving any questions about the report. I believe you've all received it and read it.
Okay, I actually have a couple, if I can. First of all, was Miss Antoine was given the opportunity to present all information during the investigation?
Correct. We interviewed Ms. Antoine and gave her opportunity at that time, and then we also said we were open to receiving any additional information at any point that she had.
Right, and did Miss Antoine give you any witnesses to verify her, confirm her side of the story or whatever?
No, we did not receive anything.
But you asked for it?
Yes, sir.
Okay. Now, allegation 2, I'll start there. I want to start there.
Can you give us the time
Excuse
that
me,
was allowed in between?
Are you interrupting me?
Can you
Are
give
you
us the
interrupting
time?
me?
I want to know the time that was allowed in between the time you actually submitted your report, because the allegations are actually
Ms. Antoine,
not answered.
Ms. Antoine,
so I just want, no, I think the public deserves to know.
Allegation 2 referred to Miss Antoine and Miss Antoine and the I think is employee 1 work together to form the grievance. Is that correct?
That was the allegation.
Okay, that's the allegation. And you said you cannot confirm that.
That's correct.
Okay. Okay, I want to come back to that in a second. Okay, allegation 3, Miss Antoine stated that she never accessed or reviewed the grievance. However, the metadata showed that she accessed and downloaded it on March 8th and March 16th. Now, that I don't know. I'm not familiar with all the technology and stuff, but that it doesn't tell us whether she actually did anything too. So we don't have any information that says she actually assisted in the grievance process.
That's correct.
But we don't have any information to show that she didn't.
There was no information in the metadata that showed she made any alterations to the grievance.
Okay, so the possibility would remain that she could have done that without doing it online. Okay.
Are you assigning me guilt here? No. Are you assigning guilt to something that they said didn't happen?
Are you threatening me?
let him finish.
I'm making a statement, ma'am.
And I'm asking if you're assigning me guilt for something they said did not happen, that they had
Ma'am,
no evidence to
Just
prove.
let him finish.
Okay, so, and please stop me if I ask a question that doesn't pertain to, I'm not sure what I can ask and what I can't ask. Can I talk about the March 9th email?
Oh, the March 9th email. Yeah, that was part of what we looked into. Yes.
Okay, I'm the March 9th email from
From Miss Antoine.
from employee one.
I think yes, you can talk about that without mentioning the name of employee
Right, that's what I'm
one.
saying. I didn't know if that was a part. Okay.
Yes.
So the March 9th email from employee one, and then apparently Miss, as you've shown, she.
I think the employee one sent the email on the 8th, if I'm not mistaken, and
Right.
then Miss Antoine responded on the 9th. I might be incorrect about that. Yeah.
And that's also the time that she downloaded the grievance.
Yeah. So we
One of the days that she downloaded the grievance.
Right.
Okay. All right. Now, as far as the email from the grievance, the individual who's filed the grievance, I apologize, all these employee names and stuff like that. The board has no authority to share that email. Is that correct? Publicly? An unredacted version, because it has the employees' names in it. Is that what I'm understanding?
Right. So anything with employees' names, we're redacting the employees' names, and it may be confidential personnel information depending on the contents.
Okay, so the only person that could share that email would be the person who filed the grievance.
I don't know. I can't
Okay.
speak to that.
Okay. You made the comments that your findings showed that the comments in that email were unsupported, disparaging, highly inappropriate.
Yeah, we made that determination based on the fact that it was shared with 3 employees of the district,
Okay.
in addition to board members. Yeah.
Okay, and the unsupported and disparaging comments simply state that the comments that were made in reference to that employee could not be confirmed. And Ms. Antoine didn't give you any witnesses to confirm that.
I think you're you're speaking about a name, a specific name. A person was called, and we tried to find support that nickname was frequently used for this for the grievant, and we were not provided with anybody who could substantiate that nickname was used for the grievant.
Okay, and it isn't your job to determine if that email rose to the level of slander or defamation.
That's correct.
Okay, you wouldn't decide that. You have you don't decide that, slander or defamation. I said it's not this investigation's job to determine whether it was slander or defamation. That would have to be done by in a different
Right.
court system. Yes, it would
we
have to be
weren't-
done by a different court.
Yes.
Okay.
That's exactly right. You're not a court. You're a school board. Your job isn't about determining legality of anything. It's just to determine the policy.
All right. Now, I will stop right there for now. I have some more.
Are there any other questions?
Ms. Cornetto, I asked you about the actual provision in general statutes to allow for hearing and investigative reports to be done in closed session that preserves people's rights. And you decided that that wasn't something that you were going to do.
Ms.
Can you-
Antoine, the law that I cited at the beginning of the board meeting references the fact that a public official must be discussed by the public body in public.
Ms. Cornetto, while you're on the microphone, I do have a couple questions for you.
Before we move on, can I
Okay.
just say one thing? That there is an exception in the general statute 143-318 that says, hear or investigate a complaint, charge, or grievance against an individual public officer in closed session, but after hearing and investigating such a complaint, any discussion among the board members, if any final decision on how to respond, would occur in open session. There's a provision in the law that allows you to protect people's rights. You've decided to sidestep that today, is that correct?
That is not correct, and that's not my legal analysis.
Okay, thank you.
Well, mine's not a legal analysis I need. It's a very straightforward question, Ms. Cornetto. Whenever you began this investigation, because if I'm correct? You started the investigation and then you turned it over to the other two investigators. Is that correct? You're nodding your head no, but Ms. Cornetto, at any point with employee A, employee B, or however they're classified, did you have any conversations with them regarding anything that may have been an origin to this? Did you?
Mr. Johnson's question is one that I'm happy to address if the board would like me to, but it's off the
Yeah,
point. of this
that is not the point of this report.
Well, it's it's an origination of this. It's the
But
basis for
it's
this.
not the question on the table about the report.
Okay, well.
That's what we're sticking to right now.
Okay, well, I'm going to ask about the investigators of the report because, we want due process. We want this to be an impartial finding, correct?
Yes.
Yeah,
but-
we want full transparency.
Oh, yeah, we want
Terry, I appreciate
transparency
the
about
full
everybody.
transparency. Thank
Yep.
y'all for that. So with that being said, Ms. Cornetto, during your times interviewing anyone, did you tell anyone that they should just separate themselves from me and their problems would go away? Did you tell anyone that?
That's not the subject of this meeting. That is not the subject. If you're questioning the actions that she did, that's another meeting. What we are laying before us right now, does anybody else on the board have questions about the report that is before us?
Did you interview every witness recommended by all parties involved?
That would be for Ms. Williams, yeah.
We interviewed every relevant witness that we thought had information related to this. I believe we interviewed all, if not close to all, of the recommended witnesses.
Did you make any contact with your colleague, I believe it's Ms. Gum, in regards to this?
I don't understand the question.
In regards to this investigation, did you make any contact and discuss this with your legal colleague, Ms. Gum?
No, I did not. You're saying during the course of the investigation, did I discuss this with Ms. Gum? Absolutely not, no.
Okay. So you would not be aware that I approached Ms. Gum and said I had additional information for this investigation based what I read in a closed session meeting? You're not aware of that?
I'm not aware of that, no.
Any other questions?
How much time elapsed between the time that you put this report in front of me, gave it to me, with what your findings were, and the time that you scheduled a board meeting?
I didn't schedule a board meeting. I don't know what you're referring to.
In between the time that I was to be brought before this board and heard this complaint that you filed, how much time elapsed? How much time did I have to actually respond to your allegation?
That's a question that's more appropriate for me, and the board had a meeting on September 12th, and you received the report on August 31st. The grievant declined to appeal the grievance findings, and therefore it was calendared for discussion on the 12th of September in open session. We were restrained from talking about it at that meeting.
So there were 12 days between the time she received the report and when it was to be discussed at the September 12 board meeting.
Correct.
Okay.
Were the allegations inside of the actual grievance complaint that I had done any of the 3 violations you actually put inside your report?
I want to address this.
I'd like her to answer my question.
No.
You allowed Terry to have his question. I have a question before her. I'd like it answered.
You need to sit there just a second.
Excuse me?
Based on policy, the only person who can appeal, am I correct? The only person who can appeal this report is the grievant.
That's correct.
The person who the grievance is filed against does not have an appeal. Is that correct?
That's correct under policy.
Okay. I just want to make sure that we understand that Ms. Anton does not have the opportunity here to appeal this report.
And
Right, per policy, that doesn't
Right.
allow that.
I want to get some clarification. Oh, I'm sorry.
Okay. So what would be we would have a route for her to state her feelings about this or her thoughts about this?
At any point in time, Ms. Antoine is free to provide the board with her statements in response to this investigative report. It's my understanding the board would like that in an affidavit form.
Right. And we can go ahead and do that. I mean, I can address that now. Matter of fact, Madam Chair, I will put a motion on the floor. I'll make a motion, even though, and I think we don't have to do this. I think we don't have to listen to this. I mean, I think we don't have to give Miss Antoine the opportunity to do this by policy. However, because you can't appeal the investigation. I mean, she can't appeal the investigation. However, I would recommend to the board, and I would put in the form of a motion, that Ms. Antoine be allowed to respond to the do not interrupt me.
Don't make me angry. You wouldn't like me when I'm angry.
We were just told that I had all times of opportunity to respond. And now you're saying I actually had no opportunity to respond. So which is it? And my question still stands before I was interrupted by the chair. Did your
We have a
violations,
motion.
excuse me, did your violations actually answer the grievance complaint?
Yes, the grievance didn't enumerate violations the way that we did. We had to, after reading what the written grievance was and speaking with the grievant, we had to basically enumerate them instead of listing out a long paragraph worth of thoughts. So we compiled all that information and enumerated 3 different grievances that we could discern from the complaint, the written complaint, and the interview with the grievant.
You never put those allegations as hers. You did, and,
Okay.
and frankly,
You
and
need to move forward with, he needs to move forward with this
and
matter.
by the
Madam Chair, I'd like
by
to
the
make a motion
grievant
that we-
complaint process.
Uninformed person, the most disrespected person, the most unprofessional person I've ever seen sit on the Board of Education or any board. Don't interrupt me right now. Now, I'm telling you,
Hey,
I'm
hey.
telling you that right now. What are you going to do?
Wait. Just sit down.
You want to threaten me?
Look.
Threaten me?
Are you threatening me?
What is happening? These guys, who are supposed to be representing an entire school district, are getting into a fight? I think we found Jake Paul's next challenger.
Ms. Antoine, the opportunity to respond to this investigation, to all 3 allegations of the investigation, to results, everything involved in the investigation, in the form of an affidavit, which she would be under oath, which would be done with the possibility for committing perjury. And she will have that opportunity to do that in the written form of affidavit, which the board will review and make public.
Sir, you've denied
And
me
make
my due
public.
process
I have
rights.
Denied her due process rights. I'm not an attorney, but I'm pretty sure that's for a court of law to decide, not a school board meeting. Just saying.
And the only
I have a
response you'll
motion.
get is
Do
in
I have a
court.
second?
If you do not allow
have a
me to
second
ask
from Mr.
questions
Carroll.
here, this is
Any
ridiculous.
discussion?
We are in a kangaroo court,
This is kangaroo court, sir.
a quasi-judicial board that can't answer a simple question.
I have a motion and a
Discussion.
second.
There's a discussion.
Any,
Discussion.
hang on.
Here's the interrogators, all 3 in 1.
Okay,
Didn't
discussion.
even ask a question.
Yeah, just point out decorum here. I mean, we just had a motion and a second, and during the meanwhile, we had a arbitrary challenge for a fight. This is out of control.
I agree. This is out of control. You want to know what else is out of control? This board member's text messages. But that's for a later video.
Like,
I agree.
mean,
I
this
agree,
is out
Mr.
of
Johnson.
control.
I agree, Mr. Johnson. I really do, and it's really unfortunate that the actions of board members
Tom-
leads this to that. So the discussion, this discussion.
It's a violation of the code of ethics for you to use your title, which you did, to fund a PAC in which these same
Miss Anton,
worked for you.
I'm entertaining discussion about the motions. Any discussion about the motion made to allow Miss Anton to present her information and her response about this report in form of an affidavit to the board, and the board will consider it. You can.
Exhibits, but that will be seen in court at this point because you have denied me my due process rights. You're going to
It was hard to hear, but she's mentioning her due process rights again. Cue Inigo Montoya.
You keep using the word. I don't think it means what you think it means.
you deny every employee in this
We're-
case their due process rights. Everyone has the right to face their accuser.
Yes, Again, though, in a court of law, not a school board meeting.
I know you don't like the Constitution, you won't hand it out to our 8th graders, but we really ought to go back to it and take a look at it and put...
Miss Anton.
Madam Chairman, call a question.
Okay, thank you. All those in favor, and I will do a hand vote, please. All those in favor of allowing her to write a response in the form of an affidavit to this. All those in favor, please indicate by raising your hand. All opposed? Okay, so 5-2.
I really wish they would have shown the hand vote. And looking at the meeting minutes, it isn't recorded who the 2 dissenting votes are. I wonder why that is.
All right, any other questions about this particular report?
Yes, ma'am. As far as the restraining order goes, it's over now. We can discuss this at length. That's apparent. When did that restraining order end? When did it come to a conclusion that allowed us to discuss this?
Mr. Johnson, as I indicated in my communication.
Ma'am, please
to the
just
board,
answer the question. I don't need a preface. Please just answer my question, not as I indicated.
Friday.
What was the point of that? I mean, really. The attorney has been nothing but polite and informative. That was nothing more than political posturing, or to put it simply, rude.
How rude!
Friday it ended.
Yes.
And when was this meeting announced?
Saturday.
The court
48
opens
hours.
Yes, ma'am. And the court opens at 9 a.m. in Johnston County. So it seems like to me you went out of your way to schedule this in haste, not to allow for due process, but to do exactly what you wanted to do. This seems like this is something you wanted to do. Why didn't we wait for the courts though? Why didn't we go to court and actually let it be heard and let an official judicial body make that decision? This is out of control. I would recommend everything else go before an official court body, because this is not due process. This is not decorum. This is not the way it's intended to be.
Well, we are following board policy, and we're following the law. We had a meeting scheduled today. We had a retreat scheduled from 8:30 to 4:30. I am the one who scheduled it at 8:30 because that is when the retreat was going to start. It's easier to do this now. We have everybody here. As soon as this is over, we're going straight into a retreat. It was simply the fact that we had all board members here. That's simply that. You don't read my mind, Miss Anton. So,
You can read minds.
wait, let me finish.
Why don't we look at policy then, Lynn? Why don't we look at policy?
Well,
Policy is that a specially called meeting is for business that cannot be conducted in a regular session meeting. You had this scheduled for the regular session meeting. What was so critical and important that it couldn't wait till the October meeting?
To follow up on Mr. Johnson's, on his we're cool. To follow up on Mr. Johnson's thing, when the emergency order was issued, the time I saw on there was 11:09. When were you notified that it was going to be heard at 1:30?
10 to 1.
Okay, so you were notified at 10 minutes to 1 that the emergency order was going to be held in Smithfield at 1:30, and your office is in Raleigh.
Correct.
And that's where Miss Antoine's attorney, Stephen Walker, let you know that you had from 10 minutes to 1 to 1:30 to get there to present the Board of Education's side, if you will, of the story for the emergency order that was being requested.
That's when I received contact from Mr. Walker.
Okay.
So therefore, it was heard before the judge in ex parte because we were unable to have representation there.
Correct.
Any other questions about the report?
Are you calling? Why don't you just let my microphone work? Is there something going on here that you won't activate my microphone?
Again, that would be a due process issue. She is here to be heard. We need her microphone on. I mean, this is crazy.
I'm trying to entertain questions about the report. Let's finish that.
Not my question.
But you're going to have an opportunity to share your story, but you're going to do it in the form of an affidavit, which is what the board just voted on it.
Ma'am, they just said I had plenty of opportunity between the evening of August 31st and the scheduled board meeting of September 12th to answer the 3 allegations that were presented by the investigators, not the grievant. The grievant didn't bring these accusations. It's the investigators that brought these accusations, which are wholly false, 100% false. You're coming here today. You won't. Oh, my mic's on. Brilliant. At least you're not denying me that right now, because you don't like the First Amendment. You don't like the 14th Amendment. Seems like you don't like too many of them. Again, you won't hand out the Constitution. I see why. Listen. This is supposed to be a hearing of my character and fitness to talk about the grievance, and you won't allow me an opportunity to state at least just some serious facts.
This is not a hearing, Ms. Antoine. This is a meeting to receive a report. This is not a hearing. This is not a court of law.
That sounds familiar.
That we are in. We are trying to have the board able to ask questions about a report that involved a grievance from an employee on a board member. That's all we're trying to do here. This is not a court of law.
Right. And
we don't have that power.
No, it's coordinated. It's a very coordinated meeting with set up questions. But when I ask a question, I'm cut off.
No, my question is not.
Oh, you cut me off. And those are coordinated.
No, my question is not set up.
Fully coordinated.
No. As a matter of fact, board members, I would suggest and recommend that the board not make an official comment or official response to what we're hearing on this investigation at this point in time. I think, again, I think this is an information only thing. For you, for us to hear for the board to hear this, to be able to ask questions about the investigation. So I would recommend that that this board not make have a response as to anything. However, I would also make reference to the board reserves the right to do so in another special session or whatever, to look at the conduct of Ms. Antoine since December 13th. And then the board can make any.
So now we're opening it up to the whole,
that we,
my whole entire.
That we choose to do so. That is my recommendation
on the board.
To the board at this time.
So we're going down, this is exactly what you did to Ron Johnson. You pick out a political target. You're up for re-election, Lynn. This is all political. And then you chase me down, and you're going to say, well, I just don't like she did this, this, and this. Well, you know what? I don't like that you used that you're using your official JCPS title for partisan gain. I don't like that at all. And that's against there. How about the $8 million? Seems every couple years we lose $10 million, $8 million, and the public never gets an answer. We have you on tape talking about hiding $8 million. Where's the investigative report on that? That doesn't seem to appear.
If anyone knows where to find those tapes, let me know in the comments below. Sounds like it would make a good follow-up to this.
You know, me writing an email asking a superintendent to do something about some behavior, that's at question. Yeah, because I'm supposed to not give, and he's considered just a standard employee. He's our standard employee now. That's who I relayed confidential information to, was our superintendent. That's what this claim is saying by our investigators.
So I'm going to point this out with all respect and decorum in a very calm voice here. We're talking about conduct, and we're talking about looking at this stuff. You know, Mr. Tippett, you just challenged me to a fight.
I responded when you threatened me. You're not going to sit there and threaten me.
Guys, we're not going. No.
You should not get this firm with him whenever
I'm saying it to him too. I'm saying it to him.
So I'm going to just.
We're not going there.
Yeah.
Look. We're not going there.
But you're there.
Here.
But we're not going there where you two are going to go at it again. We're not going there. You can make your statement.
Where did Mr. Johnson go at anything?
Yes, ma'am. So we're talking about decorum and conduct, and that just happened. You know, we're all 7 elected. So the comment, what are you going to do? You're preventing me from speaking. And the response to that is to stand up. I mean, this is absolutely absurd. And we can talk around that all we want, but that just happened. I mean, we've got 500 vacancies in this county, and we're chasing Michelle Antoine over what? An email? We got 500 vacancies in this county. We can find other things to meet about, and I think everyone should agree with that. We can find why don't we put our energy into that instead of all this? This is absolutely insane. Let it happen in a court of law. Don't try to do it here. Let it happen in a court of law.
Mr. Johnson knows a thing or two about a court of law.
And I hope not going to point anything out about your body language, but I hope that you're going to sit there and the next thing you do is apologize for that. I'm hopeful for that, but if not,
Are you apologizing for threatening me?
nobody's apologizing for threatening you, dude.
Okay.
Nobody threatened
Miss-
you, Terry.
Miss
All
Cornett-
right, nobody threatened you.
Cornett, I have a quick question for you. Am I at liberty now to discuss the conversation I had with employee one and Mr. Johnston regarding this case?
I would recommend that be discussed with the board in closed session to protect the anonymity of the employee.
Okay.
Do we have,
Do
we have any more questions from the board about the report?
What is the legal standard of review in this matter?
This is a report to the board. That's the legal standard.
In your investigation, what was the legal standard that you drew these allegations out of?
We were evaluating your conduct and employers' one conduct and matching it or evaluating it in terms of board policy. And for the employee one, which we're not discussing too much, we were also evaluating that under some codes of ethics.
I'm talking about, are you looking at preponderance of evidence, clear and convincing evidence? What is your standard that you draw your conclusions from?
I know a lot about the law and various other lawyerings.
So the standard of evidence is preponderance of evidence.
So it's a 51%, 50, 49, 51, right?
That's correct.
And how many people did you interview to come to your conclusion about
that's all in the report.
So there was 2 that said they heard something and 2 that said they didn't hear something. And based on that, you said I was not completely honest. Couldn't say I actually lied. Just not completely
Again,
honest.
you're going into an appeal process here, and I understand exactly how you feel about this. But wait, you have been given an opportunity by the board to put this in form of an affidavit.
Now, you just told me I had a response period before the September 12th
but not
board.
not to appeal the findings, not to appeal the method in which it was done. That's
I'm
it.
asking questions. I'm asking questions.
You're asking, but you're appealing. You can ask those questions. You can make those statements in your affidavit. Am I correct?
Yes, that's correct. This is not a hearing.
This is not a hearing, so you're not having an appeal. This is simply the board receiving a report.
This
and
is
having
simply the
opportunity.
board putting out to the public on a Sunday accusations, allegations by my accuser who became the investigator, not the actual grievance. These weren't the grievance allegations. You found no bearing for her claim of slander.
Any other questions? You have any other questions, Mr. Carroll?
Madam Chair, and I would make a motion that we just received this report, and Ms. Antoine does have an avenue to respond. I'm assuming, I just make the motion about that. I'll ask the question in a second. That we received this report as presented from our attorneys.
Second.
Okay, I have a motion and a second. Any discussion?
I'm assuming that Ms.
What's
Antoine
the process
will
if I follow your
would assume Ms.
affidavit?
Antoine has the ability, once she responds with her affidavit, that would be available publicly too, so she can answer the allegations in public?
With the redaction of any employee confidential information.
Can you repeat that? What was your question again?
You will have, the question was, would you have the opportunity after doing your affidavit to present your finding or what you want in public? We would receive that as a board also, your responses to all this. You in a more civil manner for all of us.
Are you acting as a court then?
I'm asking our attorneys if you have the right, after you do the affidavit, for it to be public information brought to this board, just like we have received this investigation, to present what you answer in your affidavit.
What am I
question, you
answering
have the
to,
opportunity.
Ms. Cornetto? Am I answering to the grievance allegation or the investigator's allegation? Because there's 2. So you went and made an investigation inside an investigation because you couldn't find anything, what the grievant proposed. So you went and found things on your own. So what am I answering to?
Ms. Antoine, you're free to say anything you want in response to this.
And so are you. And so you have.
I know you are, but what am I?
And my question remains, what am I actually answering to? The grievance complaint or yours?
The board's The board is
Something that we
up.
can do. Do we have a motion on the floor?
I have a motion. This is discussion.
Let's do that first. Oh,
This is discussion. The motion's on the floor to receive the report. It's been seconded. This is the discussion phase.
right, but it's not. We're not talking about the receiving the report. I mean, I understand Ms. Antoine can ask her questions.
He just asked the attorneys. He was just trying to clarify what you do with the affidavit.
Right, that's what I'm saying. But we're just making a motion to receive the report. That's
In a second.
right.
Right.
You
And-
already received it. In fact, the whole public world received it.
They sure did. Redacted.
So.
Okay, any other discussion? Okay, I'll call for a vote. All those in favor of receiving the report as it's written, please indicate by saying aye. Aye. All opposed? No. 2 noes. 5-2.
Now, I didn't, Ms. Antoine, were you finished? Because I have one more question.
You seem to have a problem with me altogether. You want
No.
to go back to December 13th and start digging through my past, seeing if you can find something.
I take that as yeah.
Nice.
Okay. A quick question for you. You went back to what Ms. Antoine said. Did you separate the allegations based on the email that Ms. Antoine sent? Was that part of the thing that you separated the allegations into? And the grievance you had a grievance that was filed, and then you had an email that Ms. Antoine sent to employee 1. So just so I understand, because I understand what I think I understand what Ms. Antoine is asking here. The 3 allegations were not specifically stated, but it's a common practice for when you have a narrative to separate it into allegations.
Right. So we received a narrative, meaning just several paragraphs, I believe. I don't have it in front of me. And then, so we could identify some themes or broad issues. And then when speaking with the grievant, we were able to further clarify those 3 issues. And that's how we came up with the 3. We did not create any allegations on our own. They all came from the grievant.
Right. Okay.
What was the initial allegation in your report?
I don't know what you mean by initial allegation.
There were 3 allegations listed at the top of your report. Allegations against me and whatever employee you're calling
Right.
her the employee.
Right, employee 1. Right, so that one has been, allegation 1's been redacted because it contains confidential personnel information.
And there's allegation 2 and 3.
Right.
What do they say?
Are you asking me to read them?
Sure.
Ms. Antoine and employee 1 worked together in drafting and or filing the allegedly false grievances. And allegation 3 is employee 1 and Ms. Antoine slandered the grievant by referring to blank as blank and other disparaging terms.
And you could find nothing in allegation 2. There was nothing there. No violation. In my report, there was no violation.
Right, we found that the conduct did not amount to a violation of policy.
And in allegation 3, which you stated was slander, which I say was 2 sentences of an email, was absolutely the truth.
I didn't use the word slander. That was the grievance word.
That's your allegation in your report. You
That's
put
correct.
nothing else about these other 3 things. And that's why I'm saying you went outside of the grievance complaint, that I had slandered her and made up 3 other ridiculous, false statements about me using thin or no evidence.
Anybody else have anything? I want to say this to the staff and students, faculty in Johnston County Public Schools. We thank you for your hard work. We thank you for
Is this
what
about
you're
the grievance, Lynn?
We thank you for what you've done and what
No,
you
you don't.
continue to do.
No, you don't. You hold kangaroo court.
Now, I will
That's-
entertain a motion
But you
to
do.
adjourn.
I asked for you to stop the circus when
Make a
I got on
motion,
this
we
board in
adjourn.
Move,
December.
second.
I have a
I
motion
asked
and a
that
second. Any
You
discussion?
stop going after people politically
Call the
and
question.
focus on students, and you refuse to do it. You just keep on
I
doing it.
will call for the vote. All those in favor of adjourning, please indicate by saying aye. Aye. Any opposed? Thank you. 6-1. 5-2. Okay.
2 people actually voted not to adjourn. In the many years I've been watching public meetings, this is actually the very first time I have ever seen anyone ever vote to not adjourn. Wow. Well, there you have it, folks. The people elected to be leadership for our children. Simply amazing. Also, if you're interested, the heavily redacted grievance is linked below. All right, guys, if you enjoyed this video, please like, subscribe, and share, and I'll see you all next time.